I understand, Darren, that somebody's going to wave a flag when I'm at least a minute away from, I'm going to watch you. Lydia, I appreciate your comments. There's a related story that I heard from the highest-ranking Polish official to defect, the foreign minister, who was sitting with General Jaruzelski when Pope John Paul II came to Poland for the first time after he assumed the papacy. And Jaruzelski sent spies out to monitor the crowd. And there were millions of people in the streets. And the first spy came back and gave his report, and it was very simple. He said, "General, there are too many to kill." And that has a lesson for us, I think. We've been silent for too long, and the only thing that's going to work, I'm here as a constitutional lawyer, but I have to tell you, the only thing that's going to guarantee success is massive political activity. And that's why I'm gratified to see you here tonight. Coupled with passion. Shortly after the Declaration of Independence was signed, one signer, Benjamin Rush, wrote to another, John Adams, saying, and I'm paraphrasing, "Do you remember that awful moment and the silence that surrounded the call for each of us to come up one by one to sign the Declaration, which we considered to be our death warrant?" We're not asked to make that kind of sacrifice, but can you imagine the courage it took to undertake that risk? We need the same kind of passion when we go down and lobby, not yelling and shaking fists, but it will come through your pores if we feel committed to this. And this is whether we're going to have the Constitution back in balance ever again. I have long felt that every school kid in Virginia should be required to read the several volumes of the ratification debates in Richmond in 1788. And the reason for that is, much like any other compact, there were representations made to secure a very close vote in favor of the Constitution from the Virginia delegates. Had Virginia not affirmed, had not adopted the Constitution, our nation probably would not have come about as it did. It was the largest, most populous state colony in the Union, or in the colonies. It was in the middle. It would have been very hard to create a union with that donut hole. But it's important that things were said to those delegates to prompt them to vote for it. And one of them was, we're going to have checks and balances. And even with that, George Mason, Patrick Henry, James Monroe, and others refused to vote for the Constitution because they wanted a Bill of Rights. But one of the representations was the states were not giving up all of their sovereignty. And another thing that they did not accede to was that a simple majority of the Supreme Court would dictate what the Constitution means. And this is the backdrop for discussing House Bill 69, which is the Firearms Act. That bill is carefully crafted to deal with the condition that the Supreme Court has left us with. But I want to go deeper and talk about how the Supreme Court, over the decades, has taken on itself a role that was never intended for it. The founders never contemplated that the Supreme Court would be the only organ, not only between the states and the federal government, but within the federal government to decide what the Constitution means. We have three branches, and many assume that all three would have an equal say in what the Constitution means. It was also assumed that the states would have some role in determining what that document meant. After all, that's what parties to a compact understand. One side alone does not decide what a compact means. But the Supreme Court, beginning with John Marshall, arrogated to itself the power to determine what the Constitution means. Let me read you the language of the Constitution that Congress uses to regulate firearms and to go about the business of coming up with a health care proposal, which Bob Marshall will talk about. It's very simple. It says Congress shall have power to regulate commerce among the several states. Very simple. That meant, to the founders, traffic between the states, actual commerce between the states. The Supreme Court over the years has expanded that to mean just about anything that can affect commerce. They can prohibit activity that will take place wholly within a state, according to the Supreme Court, if it has some effect on national commerce. This provision is a little bit more difficult to deal with, that is House Bill 69, than what Bob Marshall is talking about, because that goes one step beyond. The Supreme Court, if it ever rules that the health care proposal, as it's going through Congress now, becomes law, if it is constitutional, the Supreme Court is going to have to say that under the Commerce Clause of the taxing power, Congress can force you to take an action. First time ever that that would have been assumed by anybody as constitutional. But in this case, the bill addresses activity wholly within a state, the manufacture of firearms within the Commonwealth of Virginia. Now, there was a case, Gonzalez versus Raich, which dealt with the medical marijuana law in California. And the Supreme Court said that Congress could regulate the production of marijuana in California, even though it was going to be raised and consumed wholly within California, because the product was fungible. It was indistinguishable from product that goes outside of the state. You mix it up, it's just like dollars, you don't know where it came from, where it's going. This bill is designed to make it clear, by putting a stamp, made in Virginia, on the product, that it can be distinguished. No one can seriously argue, if they read the ratification debates in the various states, and Elliott, the compiler of all these debates, has many volumes of the debates, most of which I've read. No one, even the proponents, didn't argue that commerce was intended to reach into activity wholly within a state. It was convenient for the Supreme Court to go beyond that, though, because they concluded, particularly in the 1930s, that this country needed national legislation.